Welcome everyone to session 12 of the Thomson Rogers webinar series. We have a great turnout today. My name is Sarah Naiman and I will be your host. Today's popular topic is the interplay between tort and AB claims presented by Stacey Stevens, Michael Bennett, and myself. You can learn more about each of us by visiting our profiles on the Thomson Rogers website. Before we start today, we'd like to announce that we are continuing our prize draw this year and will offer one $50 everything card to a lucky winner at each session. The everything card is a gift card that you can redeem at almost any place you can think of. We'll pick a random number and correspond it to the order number in which you registered for this webinar. Be sure to stay until the very end to find out who the winner is because it could be you. Regarding the Q&A, if you have any questions, we ask that you please submit them using the Q&A button at the bottom of your screen. We will get to as many questions as possible at the end of the presentation. Okay, let's start with the questions. The first question is going to be for Stacey. What is a tort claim and what is the limitation period for issuing a tort claim?
Thanks, Sarah. Okay, so the tort claim is the claim that's going to be made against the at-fault party, or sometimes we refer to them as the negligent party, the people who caused the injury or contributed to the injury sustained by your clients. There is a 2-year limitation period to issue the statement of claim. The Discoverability Act says it's 2 years from the day you knew or ought to have known you had a claim, but in best practice terms, we usually issue the claim 2 years from the date of the accident.
Great. Michael, who can be in the tort claim?
First off, it's great to be here, and thank you everyone for joining. And Sarah, if you ever don't like the law business, I think breakfast television is for you. But let me just answer this question quickly so we can move on. In a tort claim, when you're suing somebody, the injured person, of course, is entitled to sue, but also their grandparents, parents, siblings, children, and grandchildren, not uncles and aunts. Most times we don't do a survey of all the family members to pursue family law claims because in car accidents, there's a fairly big deductible that would limit whether it would work out, someone receiving money in the end in those sort of cases. The more interesting cases is when you're dealing with stepchildren or step-parents, in which case it's a localized, it's a specific look at that case to see if that relationship is one that truly is of, let's say, father-son, mother-daughter, or whatnot, and those are more complicated cases.
Thanks, Michael. Stacey, what is a litigation guardian?
So the litigation guardian is a person who is appointed at the outset of the litigation to give instructions to the lawyer when the injured person is incapable of doing so. And this means whether you are a minor or considered a party under disability due to, for example, a severe brain injury.
Thanks, Stacey. Michael, what's an examination for discovery?
In this day and age where very few cases are going to trial, the examination for discovery in a tort case is the most important day of the case in most circumstances. And for a person who's suing, for an applicant, for a plaintiff, for someone going forward with it, it's like going to the dentist. It's a horrible day. The person who is injured has lawyers, maybe sometimes multiple lawyers, ask them about every intimate detail of their life. And before they have to answer these questions, they have to swear an oath on a Bible that they're going to tell the truth. And every question and answer is typed up by the stenographer. And at the end of the day, there's going to be a whole book of questions and answers about their case, about how they were doing before the accident, how were they doing after the accident, and every intimate detail of their life that somehow relates to the claim. So it's a tough day for the applicant. It requires a lot of preparation between lawyer and client. And one of the things that we're preparing is taking the client through all of your reports out there that you've been preparing on usually the accident benefit side. And in many of your reports, you've talked about things like how the accident happened, what symptoms your clients, your patients suffered at first and the progress of those injuries over time. The defense lawyers are going over your records, they're going over your reports with a feather and a flashlight. And it's the lawyer's job to prepare the client for everything that has been said about that person and to go through all the evidence and help them explain what's gone on in their lives in a short way so that the other side understands the nature of the case. Now, because at the end of the day, it's going to be a book of questions and answers that are all under oath, you expect that person who went to the examination for discovery, if this matter goes to trial, is going to say exactly what they said at the examination for discovery. Because if they don't, the defense lawyer takes out the book and says, well, do you remember swearing an oath? Do you remember saying that, you could never work again, and now you're saying you can work? Well, one is it? So the bottom line is, big day in the tort case requires lots of preparation, and the evidence that the person who's being examined is going to give at trial is the evidence they're going to give at the examination for discovery, so it needs to be done right.
Great, thanks, Michael. Stacey, what is a mediation and when does that happen?
So a mediation in the context of a tort claim is just a fancy word for a settlement meeting. So that means that the lawyers are there, the client is there, the defense lawyer is there, the insurance adjuster is there. The actual at-fault party is not there. And a mediator. And a mediator is either a judge, it can be a retired lawyer, or someone who's specialized in conducting mediations. And the whole purpose of the day is to have both parties set out the strengths and weaknesses of their case. They make offers, are usually here, the defendants are here, and then the mediator keeps moving everybody from their positions until we get to a point where, as they like to say, everyone is just a little bit unhappy, but the case gets resolved. Under the rules of civil procedure, which are the rules that govern how tort claims operate, there is a requirement to have a mandatory mediation. I think it's within 180 days of the delivery of the statement of defense. Quite often in personal injury actions, that's too soon because we don't know what your case is worth. So a lot of times we don't comply with the mandatory mediation in that period of time. Generally speaking, it can happen anytime you want it to happen, but it usually happens after examinations for discovery. Because as Michael's explained, the examinations for discovery is a really important day. And that is the time between the discovery and the mediation is really when everyone's efforts ramp up to start valuing the claim.
Great, thanks, Stacey. Michael, how long does it take to resolve a tort claim?
Forever. No, well, this is my least favorite question because every case has its own trajectory. Every case has different factors. Let me give you a great example. I'm sure all of you out there have had that patient or client who's been in 3 car accidents and there are some injuries and then there is a developing or developed chronic pain syndrome. Those cases take longer. They're hard, they're complicated, and it may require multiple examinations for discovery. Other cases that strangely, if you have someone who suffered very severe injuries and it's clearly not their fault, they were, let's say, a backseat passenger in a car, those cases strangely can settle quite quickly. So each case is different. It depends on the fault issue, how much work needs to be done there. Oftentimes, people's injuries are well developed after an accident, and it's easy to move forward and try and resolve those cases. Sometimes the injuries require at least 2 years to see if they've plateaued or settled. And then after that, it takes some more time to see if they've returned to the workforce or how they're doing. So I'm sorry to say that each case has its own answer for how long it takes for them to resolve. But generally speaking, we say to our clients it takes somewhere between 3 and 5 years. But there's no magic to those numbers. Each case is different.
Thanks, Michael. Stacey, can an accident benefits claim resolve before the tort claim?
Okay, so this is a really tricky question, and Michael and I are both going to weigh in on this because it's important, I think, for people on the accident benefits side to really understand how settlement of an accident benefits claim before the resolution of a tort claim can impact the outcome on the tort. So as Michael said, all of the evidence that we get from healthcare providers, doctors, all of that evidence becomes evidence in the tort claim, first of all. So when we look at resolving an accident benefits claim, it really does depend on the nature of their case, and there's some really specific factors that you have to look at. Keeping in mind that, the client also needs money, they've got bills to pay, they've got, a lot's happened since the accident, and there's some pressure on us sometimes to get their AB claims resolved. But first and foremost, resolving an accident benefits claim before a tort claim becomes an automatic deduction on the tort claim. So what that means is, let's say your client is catastrophically impaired and the lawyer is able to settle that claim for $600,000 or $700,000. That $600,000 or $700,000 that your client has now received for med rehab, income replacement benefits, attendant care, and housekeeping becomes a deductible on the tort side. So on the tort side, we make a claim for future healthcare expenses. We make a claim for future attendant care, future housekeeping, future loss of income. So for example, if our future care claim is $1 million on the tort side, and now we've settled the accident benefits claim for $800,000, that greatly reduces, that takes that $1 million down to $200,000, because the law doesn't prevent double recovery. So if you're getting a benefit on accident benefits, you're not going to get that exact same benefit at 100% of its value on the tort side. So that's a really big consideration to keep in mind when we're looking at, is it the right thing to do? Second of all, we also have to look at whether or not there's a risk that your client, our client, is going to be found partially responsible for their injuries. In the tort world, that's called contributory negligence. So if you've got a situation where, let's say, our client is going straight through the light and the defendant's making a left and the light is yellow, there's going to be an apportionment of fault, right? The defense are going to try to blame our client for being partially responsible for their own accident. In a situation where, let's say, there's a 50-50 liability split, we've got, again, let's use the same example, we've got damages that are $1 million, but let's say there's a 50% reduction for contributory negligence. Now that brings the value of our claim down to $500,000. And if we've got a big catastrophic accident benefits settlement, that also gets deducted. So as you see, once you start to do the math, at the end of the day, the client may end up in a far worse financial position at the end of a tort case if the accident benefits claim settled. And lastly, and this is so important, and I'm sure everybody out there who's watching has been in this experience where a lawyer resolves an accident benefits claim, next thing you know, treatment stops and the client's done, treatment team's gone. Where there is still an active tort claim, that can be so detrimental to the client's best interest. And we understand where that's coming from, because clients need the money, they've got bills, like they've got mortgage, they've got commitments. But if the client doesn't keep treating after the accident benefits claim is resolved, one, we have a huge gap in our evidence between when the case resolved and when we get to trial. And second of all, the defense counsel love that, because what they say is, Stacey and Michael, how is it that you're claiming, millions of dollars for care costs when the accident benefits claim resolved 3 years ago, 4 years ago, and they haven't spent a dime on treatment? Clearly, if they haven't used the AB funds for treatment, they're not going to need money for future care. So all in all, it's a very, very tricky situation. And in a true lawyer answer, it really does just depend on the facts of each case. Michael?
Yeah, thank you, Stacey. Consideration number one, I believe, is who's at fault for this accident. If it's going to be 100% against the defendants or one defendant and 0% responsibility on the patient, the client, it's easier to settle somebody's accident benefit case before the tort case. As Stacey explained, the deductions when someone is going to be contributory negligent themselves is extremely onerous. And only in circumstances where someone's damages would far exceed the policy limits in tort. So let's say someone had a $10 million care claim and they would be found, 50% responsible for the accident. And the policy limits are $1 million. Maybe it makes sense in that circumstance, but mostly not. If clients at fault for the accident, it's very dangerous to settle that case. Now, sometimes the client, be they CAT or non-CAT, are running through their med rehab funds or running through their tenant care monies, and they're going to run out. And they're going to run out even before the trial. And maybe, that client wants to tone down the full smorgasbord of treatment that they've been receiving before and move to a skinny package in order to keep something going between the time their money runs out and the time that there's going to be a trial. It's another legitimate reason to settle a tort case, to spread the money out further so you could even get to the tort trial in the first place. But at bottom, we're going to look at this from a very client-focused point of view. What's best for the client? We give them advice. We tell them what we think is best for their accident benefit case and best for their tort case. And I guarantee you, everyone out there, we tell them thou shalt not settle their accident benefit case unless they continue treatment, and that the money that they're getting for this settlement should be used to continue the treatment. We tell them this every time. Notwithstanding that, oftentimes, maybe there's treatment fatigue. Maybe, the clients, especially the ones with brain injuries, never believe they had an injury at all in the first place, even though they so clearly need the help. So there are a lot of different factors to consider. And I wish I had one answer, but I just don't. It's what works best in that circumstance. But this issue of can I settle an accident benefit case before the tort case resolves is important for the next three questions that we're going to ask. So do you want to ask me the next one, Sarah?
Sure, Michael. And this touches a little bit on what you were just speaking about. If a non-catastrophically impaired client runs out of funds, should they continue treatment?
Right. And, I had a long talk with actually Stacey about this yesterday. And, you can't, in answering this question, you can't ignore where the person is on their recovery arc. If it's someone who's been brain injured and, it's within the first year and that treatment that you're going to give them, or maybe it's a spinal cord injury and that treatment you're going to give them within the first year is going to mean everything. And any treatment that they get 3 or 4 years later may not be as valuable. That human piece needs to be kept in mind. And I don't want to look at this question solely from a business perspective. Sometimes you have to look into your heart and say, does this person really, really need it? And, am I willing to go on the hook of maybe not getting all my money back? So that's the first thing one should think about. But secondly, before you have if the accident benefit claim settles or they run out of funding, and you're going to continue to providing treatment on a protection to pay or some written undertaking, you got to make sure that there's a good tort case. And that includes that the fault issue is favorable to the person who's injured. Because if your money is going to be paid for from the tort case, if there is one. And you should know how strong or weak that case is. Maybe asking the client or the patient, maybe not the best thing to do. Speak to the lawyer. Ask them what the likelihood is of recovery. Ask them what the likelihood is of getting their money within a reasonable period of time. And I add one more point. If someone is a minor or someone is incapable, you have to know that if the case settles, which most cases do in these circumstances, you're going to need court approval before you get your money paid. So lots of different issues, using the right mechanisms, using some protections for yourself and the lawyer to make sure that everyone knows how this is going to happen at the end of the day is super important to avoid real problems at the end of the case.
Thanks, Michael. Stacey, Michael touched on this a little bit,
Mhm.
but what should a treatment provider consider when being asked to work under a protected account?
Um, and Michael made some great points, right? Liability is a big issue, right? Because you can't just assume, oh, well, there's a tort claim, so I will get paid. Because the reality is, if there is a big liability risk, there's a risk you may not get paid at the end of the day. Get it in writing, okay? I've come across various treatment providers who haven't gotten it in writing, who wait until just before the claim settles and like, well, oh my gosh, I haven't been paid, or the adjuster has only been paying half my hourly rate because they thought that that was the right thing to do. And I'm thinking more along the lines of social workers. So they've got this differential. And then all of a sudden the client gets handed a bill and they say, you know what? I'm not paying it. I'm not going to do it. So first and foremost, get a direction signed by the client. It's got to be an irrevocable direction, and it's got to be sent to the lawyer. You should also, when you talk to the lawyer about this, make sure that there's an understanding that if the client for some reason decides to switch lawyers or drop the case, that you get notified. Ask if there are other protected accounts. You don't want to be the 10th protected account on a file, because again, unless it's a big catastrophic case with big limits, it's risky. Has the client taken out any litigation funding loans? Those are high interest loans that clients will take from time to time to fund their daily life and to fund their daily expenses. Those loans are a first charge against the settlement funds, and that means that they get paid first before anybody else. So that's another conversation you're going to want to have with the lawyer, is just to be able to confirm that, where you are in the pecking order, so to speak, as to when you're going to get paid. And if there's an outstanding AB claim, maybe there's a catastrophic dispute, are you getting paid when that gets settled, or are you getting paid when the tort claim settles? Because that can take, there can be a difference in timing. So if you're going to do it, that's great, and we appreciate it because, as we've said previously, it's so important that the client keeps treating. So important. Important for them, for their recovery, first of all, and to keep making the progress that they were making when you were involved.
Great. Thanks, Stacey. Michael, what's a structure?
Yeah, I want to deal with this quickly. It looks like there's some questions out there that we want to get to, but a structured settlement is it's a financial instrument that's become commonplace when settling people who have serious injuries, and there's a lot of money at stake. And you give your money to an annuity company, which is like a bank or a life insurance company, at the settlement funds. And instead of giving the patient, the client, the money up front, what they do is they insurance company, the bank, they work out how much money this person's going to get each week or each 2 weeks or each month for the rest of their life. We always tell the clients this is cash for life. And, it's like sort of like a mortgage, the payments that are given to the patient client, it's a bit of interest, it's a bit of the principal each month, and the insurance company places a bet on when this person's going to die. So the cash is for life, and if the person dies tomorrow, and let's say they put $1 million into the structure, it's gone, it's poof, it disappears. If that person lives to 120, the insurance company loses. In accident benefit cases today that are catastrophic and where you're settling for, serious money, most accident benefit insurers will ask that you structure at least 60 to 70% of all the settlement funds. This is an important point for some of you out there who may have protected accounts, because the amount that you're going to get paid based on your undertaking to pay or your irrevocable direction is going to be from the non-structured portion of the accident benefit settlement. So you need to make sure that there is enough money in cash to pay all the protected accounts. The lawyer, of course, needs to be paid, and the client usually wants some money as a residual fund in case of an emergency as well. So all of that needs to be fit in. It's something the lawyer considers at the time of settlement. Structured settlements are often used in tort cases as well, although not mandatory. But when dealing with someone who there's any concern about their ability to manage the funds or their ability to use the funds in a wise way, structured settlements are strongly encouraged by both the courts and lawyers.
Great. Thanks, Michael. I'm going to go to the chat now for some questions. First question, do you get the 182-day extension if your limitation falls after the September 2020 resumption of limitation as a result of COVID?
I'll let Stacey handle that one.
I saw that question. Technically, yes, but I wouldn't bank on it. Let's put it that way. Like when COVID hit, we went through all of our files and made sure that any limitation periods that were expiring in 2020 were issued immediately. So it's there. I haven't seen any test cases yet, so.
No, I saw one actually the other day. I saw some write-up. There was, I think, an insurer who wanted the applicant to prove that the reason that they missed the limitation period by months was due to COVID. And the lot said, no, we're not going to peek behind the curtain why you took longer. We're just going to blankly give it to everyone. That's the only decision from the lot on this issue I've seen.
What about in the tort context, though? Would you be comfortable relying on the 6-month extension to limit to the 6-month extension to the 2-year limitation period?
I hate it. I would be frightened to. It just takes more time to untangle it. Someone's going to take a run at this. Someone's going to say, you could have done this, you could have done that. And that person is usually a defense lawyer or an insurance company. And they might well be wrong, but it takes time and legal costs to figure out. So at our firm, I know the safest course that we've tried to take is to just issue within 2 years and then use that extra 6 months as a safety net more so in case something really went wrong here.
Okay. This next question is really relevant to our presentation. Are there specific questions/opinions you would seek from experts in tort claims that differ from questions/opinions sought in AB claims?
Do you mind if I start with this, Stacey?
No, go ahead. Yeah.
Yes, they're very different questions. When you have a case at the LAT, the Licensing Appeals Tribunal, I call it Accident Benefits Court, the opinions need to speak to the actual test in the accident benefit schedule. So for instance, if it's an income replacement benefit, post 104, we need to see the magic words that they can't return to any employment which they are suited for by virtue of education, experience, and training. In tort, it's a totally different question. It's, will they suffer a loss of income in the future? Can they suffer a loss of competitive advantage? Are there any other reasons why someone might lose income? So especially with the income portion, the tests are very, very different. Also, in tort, we're looking for what the person needs in the future. And when I say future, I don't mean, within the next 6 months on a treatment plan. I find the accident benefit process to be very, focused on the here and now, while the opinions we seek in tort from medical practitioners or occupational therapists or future care costs report is something more future oriented. Do you want to jump in on this, Stacey?
Yep. The other thing is the threshold. In the tort claim, in order to get general damages for pain and suffering, loss of income, loss of enjoyment of life, you have to suffer a permanent serious impairment you have to suffer a permanent serious impairment that is physical, mental, or psychological in nature. And then there's this whole separate definition for what serious means. That's not applicable in accident benefits at all. So that's certainly a different question. And I think the tests are a little bit different as well. In tort, when we're talking about future damages, we're talking about real and substantial possibility. It's a different test completely. than what you
I
see on the
I
AB
know
side.
that when we send letters to you for a tort report, we're going to send you this long, lengthy letter with all these definitions, and I know we alert who we're seeking a report from of the actual questions we want answered, and then we also, I think, as a standard, give the whole long-winded definition of what a permanent and serious impairment is. So, very different.
Thanks, guys. We have time for one more question from the chat. I do see that there are some other questions. Please feel free to email Stacey or Michael with those questions after the presentation. So our last question for the seminar is, if you have a difficult AB adjuster / insurer who is unreasonably delaying and denying care, often these situations have to wait to go to the LAT to get care approved. How can this impact the tort, as often the client is not incurring care unless the provider is willing to protect? Can the tort be accessed with an advance in the situation, as the client is actively trying to mitigate their losses?
Go ahead, Michael.
This idea of an advance is something that we've worked hard on. I can remember since I've started practicing here almost 20 years ago. I know the Insurance Act has a formula for getting an advance when it's clear that someone has suffered an income loss, but the Insurance Act isn't so clear about advancing money for treatment. That all said, good adjusters who understand, BI adjusters, the tort adjusters who understand the case, they want to see the treatment continue, because they know that without treatment, someone's going to get worse, not better. And sometimes if you write them a letter explaining the situation, they will give advance funding. We guarantee that we won't take a fee from it, that all the money will go to treatment, and that whatever money they pay now will be deducted from whatever amount we either settle on or whatever the judgment is at trial. And good adjusters, we sometimes get there with that on the treatment issue. But if there's an issue with respect to fault in the case, it's going to stall this advance payment in its tracks. If the BI adjuster isn't certain that the person is seriously injured, once again, it's probably going to stop this discussion in its tracks. So it happens, it takes the right case, but by no means guaranteed advance payments.
Great. Thanks,
You want
Michael.
to finish it off, Stacey, or?
No, I think that's better. There was just one other quick question that I think I can just answer because it's a little important. Rebecca was asking, what are the limits that we referred to initially? And the limits are the third-party bodily injury limits under the defendant's insurance policy. That's the maximum amount of money the defendant's insurer will pay to respond to your client's claims.
Thanks, Stacey. And I think it came out of my mouth. I should have been more clear. When you go out there and you get automobile insurance, no one ever asks, well, what are my limits for housekeeping and home maintenance? I wish people were asking those questions, but they're just, all they say is, how much coverage do I get? And that's, if you get sued, how much will your insurance company pay if someone sues you? And usually most people who buy automobile insurance focus on that question. It's an important question, but there are other important questions too.
Yeah. Like standard, most people have $1 million in third-party liability limits. So that's to protect you if you get sued. Some people have 2 million, and then some people have higher. So those are the limits that we talk about.
Great. Thanks, guys. So we're at the end of our presentation. So we're now going to draw one lucky winner for the everything card. Stacey, can you pick out a number, please?
Oh, is my name in there, Sarah?
I don't know, Michael, did you register?
I put in, I think, a couple.
So it was registrant number 131.
Well, registrant 131, congratulations.
So that is Keith Meloff.
So Dr. Meloff, that's great.
Awesome. Congratulations.
One of the members from our team will reach out to you to find out the best way to forward you the digital card. Then be on a lookout for an email from the everything card. And with that, we're out of time. Thank you so much for joining us today, and be sure to look out for the next Thomson Rogers webinar session in March. More information will be provided on our website. Have a wonderful day.